In our last class, we discussed the personality of unborn, dead person, animal, temple, mosque, what is corporate soul, what is corporate aggregate, and then advantages of formation of company and disadvantages of formation of company. Now see, there are four ways by which one can go for doing or one can opt for doing business. One is the sole proprietorship. I'm excluding the sole proprietorship because in sole proprietorship there is no connections with the other person, or you can say that it is only for one person. For two or more persons, there are three possible business setup. One is the partnership, and partnership is governed by the Partnership Act 1932. The second is limited liability partnership, and this concept has been introduced in Indian jurisprudence in 2008 with the enactment of Limited Liability Partnership Act 2008. And the third one is the Company Act. Though this statute is new, but its previous statute have very long history from 1886. There are statutes in India governing the companies. Now the next topic is that what is the difference between these three business setup: partnership, LLP, and the company. And many time it is asked, maybe this time it will not be asked because it is OBE, so problem based question will ask, but sometimes this remain in the minds of the student. So you can write it that once the partnership, then the second is the LLP, limited liability partnership, third in the company. The first thing is on the legal status. On the legal status, I will discuss the difference between these three setup under 7-8 categories or under 7-8 head. The first is on the legal status. If we observe the Indian Partnership Act, there is no provision that provides the partnership as a legal status. Section 4 says that the partnership is the relationship between the partners, and the firm is the collection of partners. Then the liability of partners is also joint and severable, and that shows that partnership or firm is not a separate legal personality in the law. Rather, it is just a collection of partners for convenience. Yes, there are some provisions by which the partnership can possess the property other or separately from the partners. But that is also, that means that a property possessed by the partnership or a property possessed by the firm means the property possessed by both the partners jointly. Section 15 of the Section 14 talk about the property of the firm. Section 15 talk about even how that property has to be used, and even in the name of the firm account can be opened. But the nature of the partnership is that it is not a legal person separate from partners. To the limited liability partnership, section 14 of the LLP 2008 says that on registration, the LLP became capable of suing or being sued, and then acquiring, owning, all those things that you find in the section 9 of the Companies Act. And that means limited liability partnership has a separate legal existence. It is a separate legal existence. LLP is a body corporate. Okay. You can say that limited liability partnership is between partnership and the company. Here it is body corporate, but some provision are relaxed from the the partnership. Some provision are relaxed from the company law. And to the company also, by virtue of section 9, company is a separate legal personality. So on the first point, legal status, this is the difference between partnership, LLP and company. Partnership, not a separate legal personality. LLP, separate legal personality. Company, separate legal personality. The second is nature of document. Nature of document means the document by which this business setup come into existence. So the document by which partnership come into the existence is known as partnership deed. The partnership can be registered or unregistered. Section 64 of the Partnership Act, if you read, it's not make compulsory, but yes, it's mandatorily registered if someone want to take benefit of the Partnership Act. But there are instances, even some time earlier, Haldiram was the unregistered partnership. So partnership can be registered or unregistered. A partnership deed is a private document. It is not, because unless it is registered and it make available for the people, it is considered as private document. LLP has to be registered with Ministry of Corporate Affairs. Similarly, company has to register, and all these documents became the public document. Anyone can see after paying the fee. The third is the nature of control. On the point of nature of control, partnership agreement may be or may not be in writing. There are instances, because in Partnership Act 1932, you will not find that partnership created only through the writing. Yes, section 5 that of the Partnership Act says that the partnership cannot be created by status. Like you are doing the business and your son born or you married to your wife, so your wife would not become your partner for the partnership. So it is not created with the status. Okay, there must be some agreement, maybe oral or in written. Section 23, Clause 2 of the Limited Liability Partnership Act, agreement must be in writing. Section 23, Clause 2 of the LLP says that the agreement must be in writing. And similarly, company का भी agreement must be in writing. Writing में होगा तभी तो आप उसको register करवाओगे. Liability of members. Fourth one is the liability of members. So here, in case of partnership, liability is
The
always.
partnership में writing,
हाँ
the
जी, यस
partnership
भाभी.
में writing नहीं होता ना?
Writing जरूरी नहीं होता. Even without writing also you can start the partnership. Okay. Like
Okay,
under
sir.
Indian
Okay.
Contract Act, it is not necessary that contract must be in writing. Okay. So similarly, in the Partnership Act, you will not find a provision that the partnership should be created by a writing document or by a written document. Section 64 of the Partnership Act talk about registration, but that is also not compulsory, that without registration a partnership will not work. But yes, it is mandatory because there are some effect of the non-registration. Not 64, 69. 69 about effect of non-registration. Okay. Under the Partnership Act 1932, section 69 is the effect of non-registration, and there it is written that no suit to enforce right arising from a contract or conferred by this act shall be instituted in any court by or on behalf of any person suing as partner in firm against the firm or any person alleged to be or have been the partner in the firm. Because the how the court will determine without having any document. And so for that, there must be some things, there must be some document that is registered. Accordingly, the court can decide. And so section 69 of the Partnership Act says the effect of non-registration. And by that we can say that it is mandatory, but it is not compulsory. Compulsory means that without registration also a partnership can work. But for taking or if there is any dispute in that situation, if one want to approach the court, then if he is claiming that there was this agreement or I want to take benefit of this act, then as per section 69 that has to be registered. Okay, so registration is optional, it is not compulsory, but yes, it is mandatory. Okay, have you got?
Yes, sir.
Okay, then fourth point is liability of the members. Now on the liability, we have to observe all these three setups. To the partnership, liability is always unlimited, because पार्टनरशिप का तो कोई स्टेटस है ही नहीं. पार्टनरशिप मीन्स, और द फर्म मीन्स द collective name of all the partners. So suppose there are three person A, B and C, and the firm have taken loan from this person C of 100 crore. So every person is jointly liable to the 100 crore and severally be liable to the 100 crore rupees, and their liability is limited. उनकी liability limited है, they have to pay whatever the liability the firm has, similar liability they have. LLP, in case of fraud, the liability of members of LLP is also unlimited. But in case of company, if it is registered as a limited company, then the liability of its member would be limited as per their share or as per their as per the agreement that they have entered in as the member in the company. Okay, the fifth one is the transfer of share. In the partnership, you cannot say that in my place now the another person would be the partners in this. That means your position you cannot sell, you cannot transfer in the partnership, because partnership is a closed group that depend on the confidence and the faith, and so that cannot be possible. The transfer of share, the transfer of the one partner's position is not possible. Minor can be inducted, section 30 of partnership act, I think you all aware. Section 42 of the limited liability partnership act, section 42 of the limited liability partnership act says that partners transferable interest, and here the right of the partner to share the profit and losses of LLP and to receive the distribution in accordance with LLP agreement are transferable either wholly or in partly. Same facility is not available under the partnership, but yes, under the LLP it is possible. And under the company law, वहां तो पूरा section 44 है. Section 44 says that share and debenture are movable property. मूवेबल प्रॉपर्टी को कभी बेचो कभी खरीदो. And so in case of company, section 44 makes the share and debentures are the movable property, and that can be sale out, can be purchased, and it is done. Even in after 1 minute you are not sure that who would be the member of the company, who would be the shareholder of the company. And that's why the persons or mostly the lawyers, because they know all these things, so they go for LLP, because in LLP there is this section 42 where you can transfer your interest wholly or in part to the another person. The winding up. Now see, this winding up is the concept. The main thing is the dissolution. We use dissolution like incorporation, the act by which a particular institution or particular business setup come into existence. So through the partnership deed, partnership come into the existence. Similarly, through the incorporation, company into existence. Similarly, by registering the LLP come into the existence. And dissolution is the process by which it is dissolved, its name is removed. But the position or legal status of company is different from the partnership. Whatever things it having in the partnership, it is actually of the partners. But in the company, whatever property the company is possessing is not that of its shareholder, but to itself. And if you are dissolving, if you are removing the name of the company without managing all those property, then who will be the owner? बिकॉज थोड़े दिन पहले तो आप कह रहे थे कंपनी अलग पर्सनैलिटी है उसकी है, और फिर कंपनी का नाम आप हटा भी दो, उसको डिजोल्व कर दो, तो उन प्रॉपर्टी का मालिक कौन होगा? मे बी मूवेबल और इमूवेबल प्रॉपर्टी में तो रेस्ट नूलियस कर ही नहीं सकते. एंड सो बिफोर यू डिजोल्व द कंपनी, यू हैव टू वाइंड अप इज द प्रोसेस. टीचर लोग कहते हैं ना, आई एम जस्ट वाइंडिंग अप, तो उसके बाद में कुछ कुछ बोलते हैं और फिर क्लास स्टॉप करते हैं. सो वाइंडिंग इज नॉट स्टॉप the moment when one person stop the class. Winding up is the process by which उसने जो जो सारा डिस्कशन फैला रखा था रायता, उसको समेटना. And so the winding up is not applicable to the partnership. It is something that is required in the company or the even the LLP. To the governance, partnership is a closed group. Less number participate and they have the confidence in each other. So governance is very easy and with the confidence. LLP, you can say it is also easy. It's not like the company, but in the company governance is very very difficult and a very you can say long process. It's not so easy that you say and it happen. And the governance also be as per the company law. In the partnership, the governance, you can choose how the things will happen, because most of the provision under a partnership act would be subject to the agreement between the partners. And the eighth one is the nature of entity. And so that you can say no approval is necessary for using the name. But yes, in the partnership also there are certain names that cannot be put by the for the firm. Similarly, the LLP, like anything, the emperor, or that related to the government, like the Union in India, Haryana government, Rajasthan government, this type of the thing. Some or any name that have very, what you say that. Not defamatory, but a name that is not appropriate. And there is one situation where two women started the business. They put the name like prostitute, and it was not allowed. So that type of name cannot be put. Similarly, like LLP, to the company they have to earlier have to take whether this name they can be taken or not can be taken. Yes, against the public policy. Yes, Abhishek, very good. Okay. So these are the some points on which you can differentiate between these two these three setup. Okay, so with this topic is over. Now moving to the next subtopic, theory of corporate personality. This is very important and very conceptual. Many times question asked. Some basis I think you have already learnt. I have made. See the section 9, and the section 9 we have read, and section 9 says that what would be the effect of incorporation when the company is registered, and after registration a certificate will be given, and in that certificate a date would be mentioned. Like जब आप पास होते हो तो उसमें एक डेट मेंशन होती है, एंड आप किस डेट से पास माने जाओगे, जो डेट उसमें लिखी हुई है. And so similarly here, that the date that is written in the document, on that date the nature, or you can say this incorporation will have an effect. And what would be that effect? I'm reading it again just to make it just it's making it clear. From the date of incorporation, वो डेट जब कंपनी इनकॉर्पोरेट हुई, एंड कैसे फाइंड आउट करेगा? मेंशन्ड इन द सर्टिफिकेट ऑफ इनकॉर्पोरेशन। हो सकता है डॉक्यूमेंट आपने 4 तारीख को दिए, 1-2 दिन का टाइम लगा, फिर उन्होंने सर्टिफिकेट इशू की, जी आज हम फाइनल कर दिए कि आपका सारा डॉक्यूमेंट सही है और आज आपकी इनकॉर्पोरेट हो गई, और उसने सर्टिफिकेट पे 10 तारीख लिखा, तो 10 तारीख से। So from the date of incorporation, and how you will find that date of incorporation? The date that is written in the certificate of incorporation. Such subscriber to the memorandum. Subscriber to the memorandum, or you can say members. When one go for the registration of the company for incorporation, certain documents are required: memorandum of association, article of association, etc., etc. तो उस मेमोरेंडम में नाम भी होते हैं कौन कौन उसके मेंबर हैं कंपनी के। तो वो सारे सब्सक्राइबर या ऑल अदर पर्सन जो बाद में एज ए शेयर होल्डर उसके मेंबर बनेंगे, और ऑल अदर पर्सन एज मे फ्रॉम टाइम टू टाइम बिकेम द मेंबर ऑफ द कंपनी, ये सारे कलेक्टिवली इनको कहा जाएगा बॉडी कॉर्पोरेट। दैट मीन दे कलेक्टिवली विल बिकेम ए सेपरेट पर्सनैलिटी। और वो उस सेपरेट पर्सनैलिटी वो किस नाम से जानी जाएगी? लॉ में उसको किस नाम से जाना जाएगा? लाइक सेक्शन 300 में हमने बताया कॉन्स्टिट्यूशन में, दैट यूनियन मे बी इशू, सेंट्रल गवर्नमेंट मे बी इशू और बी इशूड इन द नेम ऑफ यूनियन ऑफ इंडिया। हियर if you remember that in the memorandum of association there has to be 5 clauses. The first is the name clause. So the name clause, in name clause, what name you have put? This body corporate will be known by the name contained in the memorandum. I'm just reading section 9, आप मेरे साथ साथ पढ़ सकते हैं। And the letter 3-4 line saying कि इस बॉडी कॉर्पोरेट का मतलब क्या हो जाएगा, इट्स फर्दर एक्सप्लेनिंग। अदरवाइज इटसेल्फ इफ बॉडी कॉर्पोरेट लिख देते तो उससे भी हम फ्रॉम जूरिस्प्रूडेंशियल एनालिसिस वी कैन ड्रॉ आउट कि उसका क्या इफेक्ट होगा। बट लेजिस्लेचर बाय वे ऑफ प्रिकॉशन सेड that capable of exercising all functions incorporating of an incorporated company under this act and having perpetual succession. Okay, earlier it was the common seal also, now it is repealed, with power to acquire, hold, dispose of the property, both movable, कार, कंपनी की कार भी होती है, कंपनी का स्कूटर, कंपनी की चेयर है, सब पे नाम भी लिखा होता है, इमूवेबल प्लॉट और फ्लैट जो भी होगा, टेंजेबल जिसको आप छू सके, पेन पेंसिल जो भी है, मूवेबल या इमूवेबल में रखेंगे टेंजेबल। इंटेंजेबल जो इंटेलेक्चुअल प्रॉपर्टी राइट है, उसका ट्रेडमार्क, ट्रेड नेम होगा, कॉपीराइट भी होगा अगर उसके एम्प्लॉय को जनरेट करते तो। टू कॉन्ट्रैक्ट यानी कंपनी कैन मेक द कॉन्ट्रैक्ट इन इट्स नेम, एंड टू sue or be sued for law legal purpose, it can be sued in the name of the company, or company will say company can be sued by the name of its. So that would be the effect. Now this is the outstanding feature of a company, its independent corporate existence. A company registered as an entity separate from its member, and thus the incorporation is act of forming a legal corporation as a juristic person. Okay, sorry, there was some disturbance. Yes, Ranjan Kumar asked that sir, how LLP is different from company. मिस्टर रंजन, 2 दिन से हम यही डिस्कस कर रहे हैं कि एलएलपी डिफरेंट कैसे है कंपनी से, and so many differences we have I think discussed, not with respect to LLP but rather with respect to the partnership also. So LLP have some similarity with the company, like LLP would also be a separate legal entity like the company. But for LLP, there would not be the, that professional management is not possible. That governance strictness is not possible. That registration of LLP is not so much time consuming and so much, money spending exercise. Okay, so there are many differences with respect to the company of the LLP. LLP, in the LLP you can enjoy the nature of the partnership. Again, it is LLP, this closure group, and your liability will be limited. Your liability you can fix as limited up to that extent. Your liability would be unlimited only in case of fraud. When some partners make the fraud, in that case his liability is unlimited, otherwise liability is limited. So these are the some differences. More you can, I think, read from the Limited Liability Partnership Act 2008, or in your
Thank
what
you,
you
sir.
say, specific agreement classes, specific contract classes. Okay. So the incorporation is an act of forming the legal corporation as a juristic person. Now, any of you please read section 3. अभी तक तो हमने केवल एक सेक्शन 9 को हिट किया है और सेक्शन 2 क्लोज 20 को. Formation of company, section 3, please. Any of you read. पढ़ो कोई.
Section 3, Formation of Company. A company may be formed for any lawful purpose by
Stop,
se-
stop, stop. See the first line. A company may be formed. That means it is an enabling provision. It just enable us to form a company. It's not compulsory. It's our choice if we want to opt this type of the business setup. Okay, for any lawful purposes. That means company can be formed only for lawful purposes. You cannot make a company for robbery. You cannot make a company for cheating. You cannot make a company for any business that is not now lawful, like trading in the rhino horns. It is not lawful. That is prohibited by law. Trading in the, you know, like what you say, this um, narcotics drugs or pornographic materials or other type of the literature, obscene literature. You cannot form a company for doing this type of the activity, because section 3 is clear that company can be formed for lawful, for any lawful purposes. Okay, is it clear?
Yes, sir.
Yes, move आगे चलो.
7 or more persons where the company to be formed is to be a public company.
Stop. Now the first clause, it has three clauses. The first clause is saying that 7 or more persons. Now again there is the question. The word used here is the person. It's not saying natural person. Okay. So person may be natural as well as artificial person. It must be juristic person. That means something, entity that have legal rights and obligation. So it may be natural person or it may be artificial person, but it has to be juristic person. So 7 Indian can form a company. 7 American can form a company in India, because citizen भी नहीं कह रहा वो, person. 6 Indian और एक American company can form a company under clause A. That means this type of permutation combination, you can say, it's not requiring that citizen can only form firm. It is saying that person, and person means a person from any country. unless if some person is restricted by some other clauses or by some other law, they can form the company. And here not natural person, हो सकता है 7 इंडियन कंपनी और 2 इंडियन कंपनी, 2 कनेडियन कंपनी, 2 ऑस्ट्रेलियन कंपनी और एक अमेरिकन कंपनी, वो इंडिया में आके एक जो है कंपनी फॉर्म करना चाहते हो, because it's saying 7 or more persons, and so person means natural as well as artificial person. The law regard them a person. Okay, and so it is not even requiring citizen. The person, the man may be, or the human being may be from other country also. And this 7 or more person, when they form the company, the second point is that that company will be known as public company. Got it?
Yes, sir.
Yes, read
Yes, sir.
second. Yes, read second clause.
Two or more persons where the company to be formed is to be a private company.
Yes, third.
One person where the company to be formed is to be one person company, that is to say, a private company, by subscribing their names or his name to a memorandum
Yeah.
and complying with
Don't
the.
read. Babita, don't read, because these are the formality. We are not concerned now. That means there are 3 types of the companies, 3 ways. 7 or more than 7%, that would be the public company. 2 or more person, again person means citizen, non-citizen, artificial, juristic, and natural person. Then the company will be private company. And this one person where the company is formed, then this one person company would be, for the purposes of law, would be known as private company. इसको भी private ही company कहते हैं, but this is a special case and it is introduced to in 2013 first time. ये बस 8 साल से नया concept आया. Now there is one case in our case material, and that is Salomon versus Salomon and Company Limited, 1897, AC 22 HL. HL means House of Lord. अगर किसी के पास कंपनी लॉ की किताब है तो आप देख सकते हो, कंपनी लॉ का व्हाट यू से दैट केस मटेरियल, हाँ, इस तरह का. See the facts of this case, that there was a person and whose name was Aaron Salomon. He was a leather merchant and he was doing business very well. फिर किसी आप जैसे कंपनी के विद्वान ने कहा कि एरन सोलोमन, यू फॉर्म ए कंपनी, कंपनी से अच्छा बिजनेस होता है. एंड सो इन 1892 ही फॉर्म ए कंपनी, एंड उसने अपनी कंपनी का नाम रखा एरन सोलोमन एंड कंपनी. नाउ सी द constitution of the company. This company was a public company. So public company के लिए कितने मेंबर की जरूरत होती है? 7.
7.
ओके. अब 7 उसने सोचा बाहर के क्या लाएंगे, आजकल सब दुनिया ऐसी है. सो 1 ही, हिज वाइफ, 2, एंड 4 सन्स एंड 1 डॉटर. सारे घर के मिला के उसने 7 बना लिए. एंड दिस एरन सोलोमन also not having so much of faith. So उसने क्या रखा कि out of that 7 member, majority of shares was in the name of Salomon itself. And in these 7 members, Solomon and his 2 sons were the directors. So in the board of directors, there were 3 members, Solomon and his 2 sons. The company got the certificate of incorporation, and after certificate of incorporation under their law in the Britain, like we have, this company became a separate legal personality. And at that time, it had 40,000 pound nominal capital. And this 40,000 was divided into 40,000 shares. Out of 40,000 shares, two 20,000 7 shares were issued. And इस जो issued share था, इसमें 20,001 were of the Solomon, one to his wife, one to his daughter, and 4 to his sons. Okay, so that means the bulk of the share is of the Solomon. Then the company has its separate business from the Solomon. Solomon transfer his business to the company, and he at an agreed amount of 38,782 pound, and company form हो गई. अब जिस बंदे ने एडवाइस दिया था, he did that advice for the good thing, but within 1 year this company was bankrupt, and it was at the verge of winding up. And so when it was at the winding up, there were some you know debater debtor क्या बोलते हैं उसको, creditor. The creditor approached to the Solomon that give the money to us. Yes, Vivek, I will come. And in the meeting of board of director, the it was decided that 16,000 pound was to be paid in cash or debenture to the Solomon because he transferred his business, and 6,000 pound has to be paid in cash, 10,000 in the debenture, and the charge was created on the assets of the company, like under the charge under section 100 of the transfer of property. So suppose there is a property and you create the charge, so that property cannot be sold out. Okay. In October 1893, in the next year, the company was held bankrupt, and it was made to be winding up. At that date, the company was indebted to two types of the creditors. One is the unsecured creditor, and other is the secured arreson. Because सोलोमन ने जो अपना बिजनेस कंपनी को ट्रांसफर किया 38,000 एंड सम रुपीज में, उसमें कुछ रुपीज तो उसको दे दिया, और बाकी रुपीज का कंपनी के जो एसेट थे उस पर चार्ज बना दिया डिवेंचर के रूप में. Now those unsecured creditor who gave the money to the Solomon company, they said that now in the winding up the company's asset will be sold out, so their money has to be paid first. And the Solomon said that no, you are the unsecured creditor, I am the secured creditor, so first my money has to be given. Then these creditor took the argument that you and company are the same person. You have the bulk of share, you transfer itself, and so you are not different from the company, and so real creditor are us, and so the money has to be given to us. In the first you can say in the trial court, the Vaughan William judge, the company were entitled to be indemnified by the appellant to the amount of that money. The decision was affirmed by the Court of Appeal, and then it went to the House of Lords. Under the House of Lords, the question was that whether this Aaron Solomon, who have the majority of the shareholder, and this whole company setup, whether this would be a valid company creation of law or is just the fake one, and the Solomon has to be responsible for the unsecured creditor who paid their hard earned money to the Solomon company. Now the argument was that the law says that 7 or more person, it not saying that how much share one person should possess, not equal share, not any minimum number of the share. Even in our law also it's saying 7 or more person, and 7 or more persons for becoming the member means at least one share. So that is the requirement. And when law is not making any requirement, then how we can impute such type of the requirement. Lord Halsbury says that it is necessary to look at what the statute itself has determined in that respect. I have no right to add to the requirement of the statute, nor to take from the requirement. Thus enacted to the sole guide must be the statute itself. And once the company is legally incorporated, it must be treated like any other independent person with rights and liability appropriate to itself, and that the motives of those who took part in the promotion of the company are absolutely irrelevant in discussing what those rights and liabilities are. That means लॉर्ड हेल्सबरी ऑब्जर्विंग कि जो लॉ की जो स्टैच्यूट की रिक्वायरमेंट है वो फुलफिल हो रही है. लाइक आवर कंपनीज एक्ट इट सेइंग 7 मेंबर चाहिए और मेंबर बनने के लिए मिनिमम 1 शेयर चाहिए. तो हो सकता है 10,000 में एक बंदे के पास 9,994 शेयर हों और बाकी 6 मेंबर के पास 1 शेयर हों. एंड दैट टाइप ऑफ द one man company would not lose its legal sanctity, and so it is a separate company. That means Arson Solomon and the Solomon company is a separate personality. So कंपनी ने लोन लिया था, आर्सन ने नहीं लिया था. और आर्सन जो है वो उसने कंपनी को ट्रांसफर की थी अपनी प्रॉपर्टी, अपना बिजनेस, और उसका जो अमाउंट था कुछ पेड हो गया था और कुछ पे नहीं हुआ था. उसके लिए कंपनी ने चार्ज क्रिएट कर दिया था, तो उसकी पोजीशन जो थी वो सिक्योर्ड क्रेडिटर की थी और बाकी के जो क्रेडिटर थे वो अनसिक्योर्ड क्रेडिटर थे. एंड देयर इज द रूल इन द वाइंडिंग अप दैट फर्स्ट the property, when the property will be sold out of the company, first it has to be paid to the secured creditor, then to unsecured creditor, and whatever is left has to be divided into shareholder. And so the first right is of the Solomon. And उतना ही उसका पैसा था, उतना ही सोलोमन का पैसा बन रहा था, उतना ही कंपनी के एसेट थे, सारा सोलोमन को मिल गया. ओके, got have you got this case?
Yes, sir.
ओके, सो कंपनी ने कहा कि जब कंपनी फॉर्म हो गई है स्टैट्यूट के हिसाब से तो ये सेपरेट लीगल पर्सनैलिटी होगी. मे बी इस पूरे में देखो तो दोनों बच्चे उसके लड़के भी कुछ काम नहीं करते थे, सोलोमन ही डायरेक्टर था, सोलोमन ही मेन शेयर होल्डर था, बट फिर भी जब वो इनकॉर्पोरेट हो गई तो लॉ में वो सेपरेट पर्सनैलिटी है अदर देन द सोलोमन. Similarly, before this judgment, in India, in the Condoli Tea Company Limited, In Re Condoli Tea Company Limited, ILR 1886, 13 Calcutta 43, this principle was recognized in India. There was the transfer of the tea estate from the members of the company to the company, and they were not willing to give the tax. Okay, and so the court said that no, this is that they are saying that it is the transfer from us to us as a collectively, and the court said no, the company you have formed is a separate legal personality, and so this transfer of the tea estate is from one person to the another person, so it is conveyance or so. जो प्रॉपर्टी का रेवेन्यू होगा, टैक्स होगा, दैट वुड बी एप्लीकेबल. दैट मीन इन दिस Condoli's टी कंपनी लिमिटेड case, the court held that the company is a separate legal personality. Maybe there are two persons who are having the property, like me and another person having the joint ownership in a property, and we both have a form a private company. यहाँ भी दो ही आदमी हैं, अब यहाँ भी दो आदमी हैं, प्राइवेट कंपनी में भी दो आदमी हैं. And then also if I want to we want to transfer the property in which we both have the joint ownership to this company, and taking this argument, यहाँ भी दो ही आदमी है, कंपनी में भी दो ही आदमी है, तो ये हमारे से हमारे को है, and this is not that transfer, and so no revenue, no tax. The court said no, the company that you have formed, it is separate legal personality. Maybe you are the member, you are the beneficiary, you will get the profit, but in the law it is separate legal personality. So in the Solomon versus Solomon Company Limited, the court first time held and recognized that as per the requirement of law, the company will become a separate legal entity, and the sanctity of the legal entity has to be respected by the court. Okay, guys? Any question, any query you have?
सर ये सेकंड वाले केस एक बार दोबारा बताना.
KONDOLI Condoli TEATCO. Ltd Limited, INRE Ray. So in this case, certain members of a company having joint ownership in the tea estate, and they want to transfer this tea estate from them to the newly formed company, and their argument is that no property tax, that when we transfer, the conveyance tax is applicable here, because we are transferring from us to us only. Okay, and the court said that no, this is the transfer from you as a joint owner to the company in which you are the member. Company is a separate legal personality in the eyes of law. This much. This, the Dr. Avatar Singh has said that even before this judgment of Solomon versus Solomon in India, the you know this principle was well recognized, and court maintained the legal sanctity of the company as a separate legal personality. Good.
Yes, sir.
Now see, there is another case also, the Lee versus Lee air farming. So that we would discuss in the next class. Find out this case, Solomon versus Solomon Company Limited. In your case material, you read it, and uh, Abhishek, the difference between share and debenture is that share is the proof that you have the contributed into the property, and the debenture is the proof of the uh, loan. When someone give the money, someone give the loan to the company issue a certificate, a document. This document is known as debenture. Okay, शेयर एक हिस्सेदारी हो गई, एंड डिबेंचर एक लोन का डॉक्यूमेंट हो गया, शेयर एंड डिबेंचर. So that is the difference. Abhishek, have you
यस सर.
got?
जी सर,
Okay.
समझ आ गया सर.
Okay. So with this, today class is over. We will meet tomorrow in the next class. Bye bye. See you. Please read this case. Bye.
Thank you, sir.
Thank you, sir.